The webinar will begin in 1 minute. Welcome, everyone. We are pleased that you have joined us for today's webinar titled An Overview of Probate. The webinar will last approximately 20 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Linus Sugis. Linus is the president of Advanced Underwriting Consultants. He and his team answer tax and technical questions posed by producers every day. Linus also spent 14 years working in the home office of a life insurance company in various roles. He also started, ran, and sold an estate planning law practice in the Nashville area. Linus will draw on his legal and life insurance experience during today's webinar, and here he is.
Thank you, Amber. Welcome, everyone. Glad that all of you were able to make it the day after the election. Today we're going to have an overview of probate, and as a reminder to all of you, we will have a webinar next month. First Wednesday of the month is every month for us. And during December session, we will discuss life and annuity unanswered tax questions. That's going to be on Wednesday, December 4th at our regular time, 11 a.m. Central. If you know of a life insurance producer or financial professional who would benefit from attending our webinars, feel welcome to pass word along to them. These are free of charge and open to all such folks. Normally at this time during the webinar, we vote on the topic for the following month, the second month after this webinar. But this time we've got that decided already. In January, we will have our traditional annual numbers issue where we talk about all of the things that the IRS has updated numbers-wise that will be relevant to you and to your clients. So feel welcome to join us both in December for the unanswered tax questions and in January for the numbers issue. All right, well, with that out of the way, let's go ahead and get started with an overview of probate. Here's what we're going to talk about. We're going to first touch on what is probate. Next, we'll talk about some of the advantages and disadvantages of probate. We'll spend a little bit of time on whether probate is necessary and how it might be avoided. We'll talk about the job that the estate administrator does during the probate process. We'll touch on how long the process might take, and we'll talk about simpler ways that might be available to heirs of an estate who have the possibility of probate thrust upon them, and then we'll conclude after all of that is over. So let's go ahead and get started with that with a quick definition of what probate is. I like this definition. Probate is the court supervision of the transfer of a deceased person's stuff after that person dies. Probate is the process that is recognized by which a decedent's assets can get transferred to the next people in line. And it is generally assets that are in the deceased person's name for which there has been no beneficiary designation that has been made or is available to the deceased person. So probate's the court supervision of the transfer of a deceased person's stuff. What are the pluses and minuses of probate? Well, there are some very definite pluses that may be relevant in certain circumstances. The first plus is that it's the process to validate a decedent's will or to apply the laws of intestacy. It gives family members an opportunity to contest a decedent's will if that's in the cards. It's an opportunity for an executor and in a court to come together to figure out how the laws of succession might apply if somebody died without a will. During the probate process, the court approves an executor, sometimes called an administrator of the estate. All kinds of words are used for that job, but we'll use executor or administrator as we have our session today. The decedent may have left debts prior to the decedent's death, and so probate is the process by which the decedent's creditors get identified, sorted out, and paid if they are proper creditors of the estate. Everybody who's interested in the decedent's assets, family members, creditors, anybody else who might be in line to get the decedent's stuff, get notice during the probate process. The court oversees what the executor is doing. If there are any disputes that arise as part of the sorting out process of a decedent's assets, then that's what probate's for, is to resolve those. The judge in the probate or the other court official in the process keeps track of a timeline, moves the probate process along, and ultimately the goal is to make sure that everyone who's entitled to get something gets what is coming to them. Now, having said all of that, on the plus side, what are the downsides? Well, the downsides are many, and I think the downsides are the reason that a lot of folks try to avoid probate. Probate is public. In general, people can go down to the courthouse and ask for a probate file and find out what the decedent had and who's going to get the decedent's stuff. It's one of the reasons why we know so much about the Aretha Franklin estate or the musical artist Prince's estate, is because their estates went through the probate process. The probate process is also very structured, very specific steps that have to be followed along the way. And so for somebody who is new to the process, those structured steps can be overwhelming. Probate is also time consuming. It is very deliberate in its structure, and it can take time from start to finish, particularly if there is any kind of dispute along the way. Most people choose to have an attorney involved in probate. While I'm happy for my brothers and sisters in the law to get paid for the work that they do, most people, given the choice, would prefer not to deal with an attorney, and so most people see an attorney being involved as a downside. And of course, there's an expense and hassle associated with probate, and so that's why most people try to avoid. Well, then can probate be avoided? Is it necessary in all cases? Well, we've got tools that we know about in the financial services business to avoid probate. We understand that a good beneficiary designation on a financial product will make sure that the beneficiary gets what they're entitled to without the need for the probate process. So that's one way to do it. Another way to avoid probate is with titling. The classic way for that is with a husband and wife. They often own assets together as joint tenants with right of survivorship, or in some states as tenants by the entirety. And that kind of titling will automatically allow the survivor to get the underlying asset at the death of one of the owners. And so that's a way to avoid probate. It's also possible to have transfer on death designations, sometimes on real estate deeds, on other times on financial products. These transfer on death designations are the equivalent of beneficiary designations. Again, allows somebody to avoid probate in the event of death. And then in a lot of cases, in a lot of places, estate planning attorneys will recommend revocable trusts as a way to avoid probate. Well, how does a revocable trust avoid probate? Well, what you do is that you create a revocable trust and you put all the stuff that would normally go through probate when you die, you put it in the trust while you're alive. And so that if something happens to you, the trust still owns the stuff, and the trust words dictate what's going to happen next. And through that method, the assets that are owned by the trust avoid probate. So if we are going through probate, what is it that the administrator or the executor is called on to do during the process? The first thing that a potential executor or administrator does is files a petition with the probate court to act on behalf of the estate. And then once they're appointed, they take steps to collect and protect the decedent's assets. They, in a perfect world, communicate well with the heirs. They collect information about creditors and decide who's going to be paid. If a will exists, they work with the court to confirm its validity and determine the proper heirs. If no valid will exists, then they sort out, as we mentioned earlier, intestacy. They ask the probate court to resolve any disputes that may arise. The executor's job is also to file needed tax returns. That's not just estate tax returns, might be inheritance tax returns in certain states, might be income tax returns for the decedent. And then ultimately, as we mentioned earlier, they determine who should get paid and distribute what's left to the correct heirs. That's the job of the administrator. And so if you're working with a client who is planning their estate on the front end, they want to pick somebody who would be good at these jobs. Want somebody reliable, good with money, good with detail. How long does the probate process take? Well, it varies. Depends on where you're at. But here in Tennessee, when my clients would ask me the question, this is the answer I'd give. And it's really pretty simple. It takes about a year if things go well. Things don't go well, if family members are squabbling, if it takes time to gather information about assets or creditors, it can take longer. But if it goes well, it takes about a year from start to finish. And the reason that it takes a year and it isn't shorter, in part, is because there's a very specific process for letting creditors know that somebody's passed away. And notice has to be given in kind of a public place usually, and that and creditors have to be given a while to respond to that notice. And so that's why it does take a year from about a year from start to finish if things go well. And the question is there a simpler way when somebody dies and has assets that need to go through the probate process? And the answer is maybe, depends on where you're at. And it depends on what the asset is. In some circumstances, it may be possible to produce some kind of affidavit of heirship. We used to be able to transfer real estate in some places with an affidavit rather than going through the probate process. That's gotten harder over time and may or may not be available in circumstances where probate is indicated. Some states have small estate procedures. If Illinois, for example, allows for a small estate affidavit to be used and for financial companies to be able to rely on it instead of going through a full-fledged probate process. That's not available everywhere, so check your own state, check your client's state. If you're in those circumstances, your mileage may vary. Some states have simplified administration that is available for certain circumstances where probate is indicated, where instead of going through a judge to complete the probate process, a clerk is involved, and that is very advantageous, less expensive, less of a hassle for those who are left behind. And I often get asked this question, unfortunately, Jennifer and I do. We've got somebody who is entitled to a small amount from a life insurance policy or an annuity, where the client's estate has been left the beneficiary, and the family doesn't really see it as being worth it to chase after the probate process in order to secure a $5,000 or a $10,000 death benefit. And they're right. And sometimes in those circumstances, if you can get the right person in the home office, and you have a strong relationship with the financial institution, you may be able to convince somebody to bypass the process. Those circumstances would be rare, they're very limited, but sometimes it's worth asking if the amount that you're asking about being able to bypass the probate process is small. So anyway, those are the ways to try to get out of going through full-fledged probate when somebody passes away. What are the takeaways that we hope you take away from today's session? First of all, the obvious one, many of our clients are going to prefer to avoid probate if they know that that's a choice. In some cases, the probate process is going to be thrust upon us. So I think it's important for us to know something about how it works. And I hope today's session was a little bit helpful for you to understand how that does work. And we do have tools available, primarily the beneficiary designation, to help our clients who want to plan to bypass the probate process. So I want to thank you again for joining us today, and I'll turn it back over to Amber to wrap us up. Amber?
Thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, December 4th, at this same time. Next month's webinar will be titled Life and Annuity Unanswered Tax Questions. You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again and best wishes for continued success.